Hello, this is Heejun, and I'm a South Korean lawyer. Today I want to talk about some important topic for the expatriates working in Korea. So wrongful dismissal claims in Korea. Then it's important whether the claimant is a worker under Korean labor law, and to determine there are four factors important and favoring worker status. So, for example, fixed working hours or direct supervision and wages via school HR and full-time one-site pattern. And beside of them, I want to also talk about taxation. As the first remedy that I want to describe in detail today, labor commission exists. So, if you want to file your case to labor commission, then you have to grant yourself for your case. And there are two aspects that I want to say today. That first, title doesn't determine status, which means that the labor commission looks at the real character of the contract that you have signed, and not how it looks or how it's written, how it's performed is rather more important. And then uh, a common misunderstanding that I want to correct with this occasion is that some workers are also protected. So under Korean labor law, it covers employees on term contract as well. So unfair dismissal protection apply equally to fixed term workers as to permanent employees. As a second remedy that we can think of for this kind of money-related case, of course, severe litigation is possible. So, in the case of my client, like the contract term was uh, defined, and there was a termination clause, which is written that termination permitted only for cause. And with this kind of contract, what you can think of as your legal basis is Korean Civil Act Article 390 and 393. So um, the damage that you can recover from this case is approximately the remaining wages for the unfulfilled contract period, which is called expectation damage. And uh, so I want to compare those two different steps in one full screen. So then what you have to do to deal with this kind of situation is to know what kind of steps then you have to make to deal with this kind of problem. So immediately review the ruling and review your contract and check all the conditions in your contracts are applicable to labor commission. And um, labor commission is kind of good way to start with it. So you submit your case to labor commission, then you can so that the aspects of your work as a worker can be reviewed by the experts. And the parallel track that I want to recommend simultaneously is that you proceed the CBA case as well, so that you can actually uh, recover for your expectation damages. So this is what I have prepared for today, and then thanks for listening.